Hi everyone, this is John Gerardi from Right to Life of Central California, bringing you another in our 40 videos for 40 Days for Life series. 40 Days for Life is the international campaign of prayer and presence at abortion clinics throughout the country and throughout the world. If we want to learn more about our campaign here in Fresno, get in touch with us at 559-229-BABY. That's 229-2229. Today we're going to talk about what is perhaps the most important Supreme Court case on abortion for those of us today in America in 2021, which is Planned Parenthood versus Casey. Planned Parenthood versus Casey was issued in 1992, and I need to sort of set the stage for you in 1992. In 1973, Roe v. Wade is issued. America now has some of the most permissive abortion laws in the whole world. We went from most states banning abortion to every state legalizing abortion for all 9 months of pregnancy for any reason. Remember, we have Roe saying you can only ban abortion in the third trimester with a health exception, and Doe v. Bolton defining health so broadly that every pregnancy qualifies for the health exception. So essentially, you have to have legalized abortion for all 9 months for any reason. The pro-life Democrat governor of Pennsylvania, Bob Casey, in the early 90s passed a law, the Abortion Control Act, that was directly intended to challenge Roe v. Wade and set a new constitutional standard for regulating abortion By this point in 1992, Republican presidents had appointed 8 of the 9 Supreme Court justices, including several recent appointments to the Supreme Court by Ronald Reagan, who nominated Antonin Scalia, Sandra Day O'Connor, and Anthony Kennedy, and George H.W. Bush, who had nominated Clarence Thomas and David Souter. So a lot of pro-lifers thought, this is it. This is the moment we're going to overturn Roe v. Wade. It was not the moment that would overturn Roe v. Wade. In a plurality decision authored by Kennedy, Sandra Day O'Connor, and David Souter, the Supreme Court basically upheld the chief holding of Roe v. Wade, basically that abortion has to be legal for all 9 months of pregnancy for any reason. Now, they changed some of the rationale. Instead of dividing things up in a trimester system, the Supreme Court in Planned Parenthood versus Casey looked at what's called fetal viability. Basically said before fetal viability, women have a protected liberty interest in abortion that basically states may not interfere with. States may not impose what the court called undue burdens to a woman's right to have an abortion. What's an undue burden? Good question. Hadn't really been much of a legal term of art before Planned Parenthood versus Casey. And for the next 30 or so years, it seemed to just mean whatever Anthony Kennedy thought was undue. If Anthony Kennedy thought that an abortion restriction was undue, he would strike it down as unconstitutional. If he thought it was whatever's the opposite of undue, I guess due, then he would uphold it. It was not a very reliable standard and continues to be not a very reliable standard. Furthermore, it continued the regime of legal abortion for all 9 months of pregnancy for any reason. It allows some regulations around the perimeter of abortion. For example, Planned Parenthood versus Casey allowed for 24-hour waiting periods. It allowed states to impose expanded informed consent procedures requiring ultrasounds, things like that. But abortion had to be legal up until fetal viability. After fetal viability, states are allowed to ban abortion, but again, they have to include an exception for when the mother's health is implicated. And as we learned from Doe v. Bolton, the definition of health in our constitutional law when it comes to abortion is incredibly broad. So that is the law in the state of California, for example. We don't allow abortions after the point of fetal viability, approximately 23, 24 weeks, but we will allow abortions after that point if there is a threat to maternal health. And because of the way that Doe v. Bolton defined maternal health, it's so broad that any pregnancy implicates maternal health. We still live more or less under the Planned Parenthood versus Casey doctrine. States are allowed to pass certain kinds of laws like parental notification, parental consent laws. Planned Parenthood versus Casey struck down a requirement that a husband be informed of his wife's abortion. And we are still on that playing field right now. The hope is that with the current Supreme Court, particularly with recent Trump appointees, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, that we can toss out the old Planned Parenthood versus Casey standard and give states greater latitude to actually ban abortion and maybe even to get rid of the ridiculous Doe v. Bolton health standard. For Right to Life of Central California, I'm John Gerardi.